Good afternoon. Welcome to today's webinar, Earning Your Keep. Maximize your value by mastering negligence actions, an interactive webinar designed to discuss the elements of a negligence action. Given the high percentage of cases involving allegations of negligence, it is important that an expert witness understand the legal foundation of these actions. Specifically, Craig Heidemann and Nathan Duncan will discuss the prevalence of negligence actions, variations on a theme, negligence, medical malpractice, product liability, premise liability, negligent hiring, and retention, the elements of a negligence action, the role of an expert, and the standard of care. The presenters for today's webinar are Craig Heidemann and Nathan Duncan. Mr. Heidemann is a shareholder at Douglas, Haun Heidemann, PC. His practice is limited to serious personal injury claims, wrongful death, class action, civil rights, pharmaceutical products liability, felony and misdemeanor criminal defense. Throughout his practice, Mr. Heidemann has recovered significant dollar settlements and judgments for his clients. Mr. Duncan is an associate at Douglas, Haun Heidemann, PC. Nathan attended law school at the University of Missouri, Columbia, where he earned his Juris Doctorate degree in 2007. Nathan is a member of the 30th Judicial Circuit Bar Association and the Missouri Bar. He's also admitted to practice before the U.S. District Court, Western District of Missouri. We encourage everybody to submit questions during today's presentation. Please use the chat feature or the Q&A feature, which is found on the right-hand side of the screen, to submit your questions to Craig and Nathan, and they'll do their best to answer these questions as quickly as possible. The panelists have done their best to incorporate the questions that were sent in by attendees prior to the presentation. Again, if you have a question that pertains to the presentation, please use the chat or Q&A feature located on the right-hand side of the screen. Monday morning, we will be sending out a link to the archived recording of this event. We do ask that you take time to fill out the survey that will appear on your screen after the webinar is over. With that said, I encourage you now to sit back, relax, and enjoy the presentation. I'm now going to turn it over to our distinguished panelists, Craig Heidemann and Nathan Duncan. Craig and Nathan, it's all yours.
Thanks, Matt. Can you hear us okay, Matt?
Yep, hear you loud and clear.
Super duper. Hi, my name's Craig Heidemann, and I'm here with Nathan Duncan. Hello. And we're going to be discussing today negligence actions, and particularly how you, as expert witnesses, can maximize your value, make yourself more desirable and marketable as expert witnesses by mastering negligence and the various components of a negligence action.
Now, negligence actions are one of a class of legal theories called torts. Now, torts should not be confused with torts.
Well, that looks good.
Tasty torts.
Different thing.
All right. Torts generally are considered to be civil wrongs. Other than breaches of contract, the court then provides remedies, typically money.
So if you're charged with a crime, that's a creature of criminal law. If you're sued for something, it can be a creature of tort or a creature of contract or perhaps administrative law. But what we're going to be focusing today on is of civil law, the law of tort.
Yeah, negligence is an example of a tort theory of recovery. Other theories of recovery are intentional torts.
Now these are subclasses of torts. We're gonna kind of move fast here for the first half, just to lay the meat on the bones of negligence, and then we're going to talk about the role of the expert in the second half of the hour. But intentional torts are those things which somebody might do on purpose: assault, battery, slander, defamation, arson,
false imprisonment,
malicious prosecution,
intentional infliction of emotional distress. Those sorts of things. Negligence, we'll talk more about.
Negligence, we're going to just think of that right now as carelessness.
Property torts like trespass or conversion, taking somebody's belongings. And then there's constitutional torts.
Such as the 1983 action. They're torts that are created by statute, where one breaches an established standard of care and violates a law passed by a legislature or Congress.
Now, one of our participants asked about different kinds of culpability. There's some different phrases we use, and wanted to know how you distinguish between them. We hear, the words intent, negligence, recklessness, and fraud. Those come up a lot in your practices as experts.
They're all different things. They're legally independent elements which might make up a negligence cause of action.
So, we just went to the Black Letter Law, referring you to Black's Law Dictionary. According to the dictionary, intent in the legal field is the willingness to bring about something planned or foreseen, the state of being set to do something.
For instance, if I'm designing a lawnmower and I want to design it to cut off most people's fingers that use it, and I intend that result, yes, I'm negligent because I intended the result to occur. So even though I do something intentionally, I can still be found to have acted carelessly.
Right. All right. Negligence, generally defined as, and we'll get more specific, but generally you can use this definition: negligence is characterized by a person's failure to exercise a degree of care that a person in a similar situation would have done.
For instance, if I'm in the diving board designing business and I decide that I'm going to design super slick diving boards that don't have any little nubbies on it to provide increased traction and people bust their heads on my diving board, I might have acted negligently.
All right, now here's where things get muddy, and that's when you start talking about recklessness. Get your mud boots on.
I got my mud boots on.
All right. Now, recklessness falls in between intentional acts and negligent acts. So you may not, if I rear back and punch Craig in the nose, I probably did that intentionally. If I'm waving my hands around to somebody in a tight room and I smack Craig in the face, that might be negligent. And recklessness falls somewhere in between there. It's kind of a nebulous concept.
Let's say I decide to go target shooting, but the kids are out playing hide and go seek, and I decide I'm going to use a bush as the backdrop, but I don't bother to go look behind the bush to see if the kids are playing hide and go seek behind the bush, and I shoot my gun, not intending to kill or shoot anyone, but I strike a child. It would be said that I've acted recklessly. I didn't intend the consequences, but I disregarded a substantial and unjustifiable risk that the harm might occur.
Now, obviously, there's some overlap between intentional acts, negligent acts, and recklessness. Like we said, the recklessness, that concept is kind of fuzzy, and as experts, that's one of the roles that you're called to fill, is to determine where those lines are using your expertise, the line between intentional acts and reckless acts.
For instance, if you opine negligence or report at your deposition, maybe an attorney asks you, well, have you made a determination whether the conduct you described was intentional, negligent, or reckless? You'll be prepared knowing the difference between those standards legally to answer that question. And I think you'd impress your hiring attorney by having a functional working definition for each of those.
Especially if you can point to specific facts that you looked at when you made that determination of whether the person acted intentionally, recklessly, or negligently.
Right.
Now the fourth thing our example of recklessness.
Jessica Dubroff. We had the girl in the news that's recently been found in the southern Indian Ocean, a 16-year-old that was sailing around the world, to remind us of the 1996 case of Jessica Dubroff, the 7-year-old who was going to become the first girl to fly coast to coast. In that case, and just to put a point on recklessness, she and her father and the flight instructor were killed because their overloaded aircraft took off in heavy rain in the thunderstorm. So if somebody is filing suit for wrongful death and you've got a father that lets a 7-year-old take off a Cessna 172 from a high-altitude airport during heavy rain and a sudden storm, even though a flight instructor's in the plane, one might argue that that was a tad reckless. Ultimately, I think they found that there was turbulence, gusty winds, advancing thunderstorm. They were in a hurry. They'd set an overly ambitious plan to get across the country, and so that's really where I think you could make a good argument that that was reckless behavior.
Well, and one of the things they determined was that the flight instructor was the one that was manning the controls, so that that might factor into whether.
Yeah, you could argue, an expert could argue it wasn't reckless because it wasn't the girl that was piloting the plane, but the flight instructor. All right, on to fraud.
Bernie Madoff,
a
very recent example of our fraud.
Fraud is where somebody says something that's not true, and we hope that somebody else relies on it to their detriment, and they do reasonably rely on it to their detriment. It's an intentional misrepresentation or omission of a material fact. So
you can also have a negligent fraud where, say you did not take reasonable steps to determine that the statements you were making were in fact true.
Fraud.
Could be fraud. So a little different from the three things we talked about, the intentional acts, or reckless and negligent. But
fraud often falls under the category of intentional torts because normally it's done intentionally. We intend to misrepresent someone.
Depending on your jurisdiction, your jurisdiction might recognize negligent fraud as well. So it might be called misrepresentation. All right, but today we're really going to hone in on negligence. Now, I'm sure you have experts have seen this in a variety of ways. Negligence manifests itself in all these different types of claims.
It doesn't matter what we call it. These are all negligence claims. 1 through 13, there's really no difference. When it comes to, from an attorney's perspective, at the end of the day, if we submit these cases to a jury, all 13 of these subcategories of negligence claims, we're going to submit a verdict directing instruction to the jury, and it's going to say, look, here in this case, we want you to find that so-and-so had a duty. Their duty was to use reasonable care. They breached their duty in such and such a manner. They were negligent in doing that, and it directly and proximately caused our damages. And if you're defending that claim, if you can knock out any one of those necessary elements, you'll prevail in your defense of that claim.
So, as you can see, given the different types of negligence actions, it should be obvious that, negligence is a very common cause of action used by lawyers and people to get recovery. So that's part of the reason we want to talk about this today is how common negligence actions are in the legal system.
If you've worked in any of these 13 areas, you've worked in the area of negligence. You might think of yourself as a medical malpractice expert or a products liability expert or perhaps I only do trucking accident cases. Well, really you work in the area of negligence and you're qualified in many cases to opine across these areas depending on your areas of expertise.
So Craig mentioned just a minute ago what the basic elements of a fraud or a negligence action are. Now these are the 4 things that are drilled into us lawyers in law school, what you have to prove to establish negligence.
And I would expect that every expert that's holding himself out as a professional expert should know these from memory.
Right. The first one's duty. Second, a breach of that duty. Third, that the breach and duty caused some kind of damage.
Duty, breach, causation, and damages. And, with those 4 elements, we've established a basic negligence claim.
Now let's talk about these in greater detail. Duty is frequently linked to the standard of care. And I'm sure you've heard that phrase before, standard of care, as you've given depositions, prepared expert witness reports.
And it doesn't just limit itself to the medical field. It applies to industrial design, product safety, flow control, medical negligence, legal negligence, operating a motor vehicle, tire design.
Anywhere you have a negligence action, the person that the plaintiff is claiming acted negligently owed the claimant some kind of a duty, and that duty was to act a certain way. We call that the standard of care.
Now there's ordinary care, which is in most things using that degree of care that a reasonably careful and prudent motor vehicle operator would use in the same or similar circumstances. If it's a dangerous activity, there might be a higher degree of care where they would have to use the highest degree of care, like a surgeon has to use the highest degree of care because of the particular consequences of failure in those kinds of things.
And doctors, even more specifically, doctors are expected to use that degree of care that another doctor in a similar field under similar circumstances would use. Generally speaking, when we're talking about standards of care, you want to use the same degree of care that a reasonable person in that situation would have used. Like we talked about, different situations call for different standards of care. Car accidents, slip and fall, medical negligence, products liability. Toyota's lawyers are well aware of what standards of care are.
All right, breach, on to breach. And you know, this is an opportunity to really maximize your value as an expert. It's fact intensive. How was the standard of care violated? This depends on lots of things, and it allows you to use your expert powers of observation, your ability to write persuasive, detailed, scientifically based reports. This is an opportunity where you can really add value. You've been hired, you want to do a good job, you want to shine, you want to be objective and independent. This is where you can really take it to the next level.
Well, and one of the ways you do that is you show how familiar you are with the facts. Like we said, you know, establishing that somebody has violated that standard of care, showing the breach, you want to be able to point to specific acts or omissions that the negligent party has done and say, this is how that party violated the standard of care.
For instance, maybe in a rear-end collision case, you're an expert who wanted to opine on stopping distance or something like that, and it's obvious that the collision was a rear-end collision, and maybe the other person admits that they hit them in the rear of their car. You might be able to take that as an expert and break down what happened in 2 or 3 seconds of time into little nano slices and explain, you know, a reasonably prudent driver paying attention would have recognized they needed to stop now, but in this case they didn't, and they continued to drive forward, and another second passed, and yet they had an opportunity to stop, but they didn't, and another second passed, and whatever. You could really stretch that out and just use your expertise and your knowledge to really drive the point home that this was a glaring breach where maybe the other side just wants to admit it and gloss it over and move on.
Well, and even though some of those facts may be obvious to a jury, to a judge, to whoever your audience is, there are opportunities to make impact with pointing to those facts. You know, it can be very persuasive.
Right.
To run down your list of, look, there's A, B, C, D, E, and F. All these things show exactly how this person breached the duty.
Well, and it might be obvious to us as professionals, but, you know, to the layman, if we're going to try and explain things to a jury, I always try and explain them at a 3rd or 4th grade level just to make sure that I'm clear. Explaining the obvious is an opportunity to add value.
Well, and the person maybe can see the act, but being able to explain how that violates the standard of care is very important.
You know, and if you're defending a case, you want to also not miss the opportunity to explain how there was not a breach if you're testifying for the defendant. So you can really stretch that out and maximize the work that you're doing in the case. All right, what's next?
We're going to talk about causation. Now, this is very important. There's two different kinds of causation, I suppose, for negligence actions. First, but-for causation. That's if A didn't happen, B would not have happened. So
it's called direct causation.
Direct causation. So, for example, a car accident. But for one driver getting out of bed in the morning, accident would not have happened. Collision would not have happened.
Not really negligent.
Not negligent. And that is not the standard. You don't have to prove but-for causation to establish a negligence action.
Let's take it one step further. Let's say that there's a traffic control device, a red light, and the car fails to stop at the red light, enters the intersection, fails to yield, and strikes another vehicle. But for their failure to stop at the traffic control device, the collision would not have occurred.
Now, that would also be enough to constitute proximate cause. What's proximate cause, Craig?
Proximate cause is the legal cause of the negligence. We hold people accountable for what proximately causes, the immediate cause of the collision, the thing that they had a responsibility to prevent by behaving reasonably.
So that's, I mean, when you're looking at proximate cause, you're looking temporally. You know, how close in time was the breach to the damage that somebody suffered? That's a good indication of whether there's sufficient proximate cause.
Now, for you defense experts, I've added intervening cause. It's an affirmative defense. If there's an intervening cause where I intend to kill someone and I fire my bullet at them, but before my bullet hits them, they drop dead of a heart attack because they like bacon and eggs in the morning for the last 40 years. I intended to kill them. I shot a bullet at them and they died, but my bullet did not proximately cause their death. There was a subsequent intervening cause of their death, which was the heart attack from atherosclerotic heart disease, which caused them to die. So that would be a great affirmative defense, and if there was an intentional tort case, or a wrongful death case. All right, onward and upward to damages, the last and final and in some cases most overlooked element of a negligence case on behalf of expert witnesses.
Because you can have a case where somebody is clearly owes a duty, has a standard of care, and violates that. I could be driving my diesel on the wrong side of the road drunk, and then plow into somebody else. If that other person doesn't get hurt, if they're Superman, doesn't have to go to the hospital or anything like that, that person has no claim against me for any physical injuries, and wouldn't have a negligence action.
And expert witnesses, even those that are called to testify about causation or about a duty or standard of care, why not spend a few paragraphs in a report on damages, even if maybe you're not even hired to do it? Think of the value that you're adding to the case. As long as you are competent and qualified to opine on some of the issues of damages, go for it. Your attorney's going to appreciate it. It will show your expertise, and you can really show that you're doing your best to help them maximize to offer your what's the word I'm looking for?
Well, it's a bonus, really. You're not expected. I think the typical mindset is, my experts are going to talk about standards of care, what other people in that industry or field are supposed to do. They're going to talk about causation, and a lot of times there's opportunities where somebody could talk about damages, but it's just overlooked.
All right, what do we got next?
Defense.
The defense.
Now, there's several defenses to a negligence action, and we wanted to run through a handful of those so you're familiar with what they are. The first one is just absolute and total denial that the plaintiff even has a negligence action. Now, Craig mentioned this, when a plaintiff submits his or her negligence case to the jury, if the defendant has disproved one of those elements, duty, breach, causation, or damages, then the plaintiff doesn't get anything. So, as far as denying, you can disprove all four elements, you can disprove one element, but that would defeat any negligence action.
Comparative fault. That might be where, you have somebody that has been injured by the negligent party, but perhaps they were also behaving carelessly at the time. I keep coming back to automobile cases because they're so easy to use. You might have somebody that is injured in an intersection collision because the defendant driver ran the red light, but at the time the plaintiff driver was exceeding the speed limit and entered the intersection more quickly, and maybe the accident wouldn't have happened if they were driving at the speed limit. And so the jury would be asked to assess fault to the defendant, but could also assess fault to the plaintiff driver. And the state laws vary widely in this area, but in the era of tort reform, the pendulum is swinging towards the plaintiff has to prove that the defendant was at least 51% at fault in order to recover. In a pure comparative fault state, if the defendant is even 1% liable, they can recover, and then the damages are prorated against that percentage. So that's the concept of comparative fault.
And comparative fault is the child of contributory negligence. So this is basically has been done away with in just about every jurisdiction. I think North Carolina still has it as a total defense. But
if the plaintiff is at all negligent, they can't recover.
No recovery. Failure to mitigate damages. If I, as a plaintiff, am injured as a result of the negligence of somebody else, if I don't take any steps to lessen the damages that I suffer, then my ultimate recovery can be reduced.
And this is an opportunity to add value. If you're a defense expert, failure to mitigate damages is something that you should be on the lookout for at all times, because you might see from the facts of the documents or depositions you reviewed, look, this plaintiff's claiming to be injured, and maybe they were injured, but let me tell you, they could have lessened or eliminated all or some of their damages by merely doing A, B, or C. That's a great opportunity. For instance, we've got an expert on the line that's an expert in banking law. One might say, they watched their bank mismanage its investments, and they watched their investments fall and fall and fall, and they knew that all of the folks at the bank were doing all of the wrong things, but yet they left their money there. They didn't move them next door to the other bank whose investments were rising and rising and rising at the time. So was the bank careless? Sure. Did they mitigate or prevent their damages? No. So that might be a good defense or a good issue to raise.
Assumption of the risk, that's where if the plaintiff has knowingly subjected him or herself to the damage. If Craig says, here's a ladder, go climb this ladder, and I look at it, and it's obviously a rickety ladder, but I don't say anything, I climb right up, and the ladder ends up breaking, and I fall and break my neck. Craig could argue, look, he had a good view of what the problems were with the ladder and voluntarily walked right up. So you should reduce it. I should not be held liable for his problems.
Any more than Nathan should be held liable if I decide to go to the Nathan Duncan rock quarry and stand in the middle while Nathan conducts his blasting operations and I get rocks in my eye. I mean, I know that there's something going on that could result in injury, and I assume that risk because it's obvious.
State of the art.
In a products liability case, if you design what's something that's dangerous? Saws, for instance. If our saw is as safe as it possibly could be, you can't make all saws safe because they're sharp and they spin fast and they cut things off. And they have the ability to cut off parts of your body. If you have the safest saw that we're making these days and it results in injury by the very nature of the vice of the saw, we've complied with the state of the art, and that can also be a defense.
And finally, seller in the stream of commerce. This is also connected to products cases. If typically a plaintiff can sue and does sue not only the entity that manufactured and designed the product, but also the entity that sold the product. Sometimes those sellers can have a defense if it can be established that either the manufacturer or designer can be totally liable for the plaintiff's injuries.
I mean, just briefly, there's a concept of upstream liability and products liability. So if Walmart sells a lawnmower and the lawnmower is made by Briggs & Stratton, I can sue Walmart and Briggs & Stratton even though Walmart did nothing but sell it. Walmart might go to court and say, look, let us out of the case because Briggs & Stratton can take care of all of the plaintiff's damages, and the court may or may not choose to let them out.
Well, and we've had this happen to us recently. Walmart tried to get out of the case, but the court decided that because it wasn't clear that the manufacturer of the product was going to be held totally responsible, Walmart was forced to stay in the case. So it's a possible defense, but not always rock solid at the outset of the litigation.
All right, got some time for some Q&A.
Yeah, I think one of the questions that somebody submitted was whether all negligent cases can also be called personal injury cases. No, I think there's negligence does not always lead to personal injury. Personal injury typically are those cases where someone has suffered a physical damage to their body.
Broken arm, a broken leg, lost their eye, etc.
So somebody can be negligent and cause damage to your property.
Sure. Like for instance, maybe somebody next to you decides to. Well, here, let's use a agriculture case since we're in the Midwest. Let's say that your neighbor is using the Roundup Ready soybean, and that allows them to spray Roundup right over the top of their soybeans, and it doesn't kill the soybeans. But next door, you don't use those fancy genetically engineered Roundup Ready soybeans. You plant traditional soybeans, but your neighbor decides to go out and spray his Roundup on a very windy day, and that herbicide lands next door on your field, and it wipes out your crop. No personal injury has resulted. We've had, potentially massive property damage with lost profits, lost revenue, etc. No personal injury. That'd be a straight negligence cause of action for property damage.
Well, and we've talked about fraud. There's the concept of negligent misrepresentation. If you negligently make some kind of a statement.
Mr. Duncan, I'd like to invest in this stock. You're a stockbroker. Is this a good investment for me?
Of course, go right ahead.
And Mr. Duncan doesn't know anything about my expertise, my needs, my risks, or that stock. He's negligently misrepresented that that stock would be a good investment for me.
But that wouldn't typically be classified as a personal injury action, even though I've been negligent by not getting additional information from Craig or by looking at the actual investment. So personal injury is just one subset of negligence actions.
But another question.
What if I guess we're still on fraud here, if the misrepresented information did not affect the outcome of the work? Fraud.
That is one of the necessary elements is causation in a fraud case. So if there was a misrepresentation that was relied on, but it didn't cause the outcome or it didn't cause any damages, then you'd not be able to make a submissible case for fraud.
Right. That's one of the cases where you may not have been totally accurate, but the result would have been the same. The plaintiff would not have been damaged.
For instance, in our investment case, you say that's a great investment for you. Nathan doesn't know anything about anything, but the market moves the other way and we make tons of money on it. Yes, he committed fraud, but there were no damages because the outcome was positive instead of negative.
Craig would not be able to sue me. In fact, you should come and thank me for my advice. Stephen Carr asks if some of these opinions are legal opinions, and we'll get into this a little bit here in the next little bit.
I mean, ultimately, what that means is an expert can't testify about the ultimate issue that the jury has to decide on, but by gum, you can testify pretty close to it. I mean, standard of care is, and we're going to talk about this in the next half hour, is fact-driven. I mean, the facts of the case and the standard of care are so tightly integrated that, you can lay out a roadmap that is so precise that you might as well be allowed to say the words, the defendant, you do get to use the words, the defendant acted negligently in that he insert description here. So, in my 15 years of practice in law, I am reminded daily that attorneys don't know how to make objections. And just because you're given a deposition and somebody's objecting that, this expert, I object, he's testifying about a legal issue, that doesn't mean anything until you're sitting in front of a judge, which, keep in mind, 97% of all cases that you testify in are going to settle before trial. So if you're one of the 3% of experts whose case makes it to trial, and a judge tells you, objection sustained, that's a legal opinion, I would just testify about as many facts and the application of those facts to the standard of care as I could.
Well, and I think our experience is that judges are understanding of, that's a close call between the legal and factual distinction when you're called upon to make opinions about the standard of care. And I think judges are understanding of that and give you a little leeway on how you testify. That's actually a good segue into our next.
Let's see, do we have any other questions?
Craig and Nathan, we have one other question here from Maria who asks, when explaining an expert's value to a potential referring attorney, how can you best convince them you can add value to the case? She's a loss of earning capacity expert, and oftentimes attorneys don't get how big of a component this is to a personal injury case.
Well, I'd tell her obviously you need to be able to explain your unique value proposition in 3 sentences or less to get somebody's attention. And what I'd say is, most personal injury attorneys commit their malpractice by not retaining a loss of earnings expert, thinking that somehow they're going to be able to stand up and explain this to the jury, where many judges have held it requires expert opinion. And I think you could give some examples of attorneys that have gotten in trouble with their cases, working them up for trial and not having that component of their case ready to go. It's complicated. It's not easily understood by a jury, and you don't want to rely on the injured, oftentimes inarticulate plaintiff to be able to explain it to the jury.
Well, here's the other way is money talks, flat out. I think the plaintiff's bar, if you can show them, look, these cases, the plaintiff's attorneys did not retain a loss of earnings expert witness. They recovered this amount. In cases where loss of earning experts have been retained, this is the average recovery. If you can, provide some kind of proof, that would be very persuasive for me.
Well, yeah, and loss of earnings experts can take a case for lost wages on a catastrophic injury case of a 35-year-old man in an industrial accident that was going to support his family for the rest of his life into the stratosphere. I mean, when we stand up there in voir dire and we say, ladies and gentlemen of the jury, this isn't a big case where we're going to ask you for tens of millions of dollars, but it's not a small case that we're only going to ask you for hundreds of thousands of dollars for. It's a medium-sized case that we're going to ask you for millions of dollars for. We better be ready to prove to the jury that our case is worth that, and having an expert like a loss of earnings expert to explain that is something that we just can't do without. And I think, attorneys are sometimes afraid to ask for more money because they don't think they can prove it, but they never bother to visit with an expert to talk to them about it. So if you can take some of these concepts away, it was Maria, I think, and use this kind of logic in speaking with prospective attorneys that might hire you, it's going to register with them.
Well, you can use that. You can use the lawyer's language and say, look, one of the things you have to prove is damages, and you may be solid on your medical expenses, your other things, but where you're really missing the boat is on this loss of earnings. So I can get you down the road.
Well, and here's the other thing: components, and we'll wrap up with this. But with components of damages, non-economic damages like pain and suffering, that's a big, what if. But lost wages, those are economic special damages, and if you can put it on the board in black and white, juries are going to be more likely to give you those numbers because they're solid numbers. So it's important stuff. All right.
Excellent question.
Thanks, Matt. Okay, an expert's role. We've got two rules of evidence. For those of you that have been with us in our earlier webinars, you're familiar with these. Everybody should be familiar with Federal Rule 702 and 704 governing the admissibility of expert testimony.
Now, under 702, experts are called upon and can testify on matters. The rule, says they can provide testimony to help the fact finder determine facts and issue, where it's a complex issue that the layperson may not understand. In those situations, the federal rules of evidence permit expert witness testimony.
Including sometimes testimony on the ultimate issue. If it's appropriate for expert opinion, and not all it is.
Now, in each of these elements, these four elements we talked about, duty, breach, causation, and damages, there are aspects that are so complex that expert testimony is perfectly acceptable and required under these rules.
Meaning without it, you can't make a submissible case. If I'm going to prove what the standard of care is for designing the seal on the solid rocket booster of the space shuttle, I better have an expert to explain that because it's outside of the general knowledge of a lay witness.
Now, Rule 704 goes back to that question by whoever it was that asked about the objections. Rule 704 of the Federal Rules of Evidence says that except as provided in Subdivision B, testimony in the form of an opinion or inference otherwise admissible is not objectionable because it embraces an ultimate issue to be decided by the trier of fact.
And let me just reemphasize, and it may sound like I'm being flippant, but I'm not. Many of the attorneys who will be examining you at deposition do not know how to make objections. Just because somebody has a JD after their name and they have the ability to take a deposition doesn't mean that they know anything about objecting to your testimony. And so I would not assume, by virtue of the fact that an objection has been made, that you've done anything wrong or you should change your testimony in any way.
Now, so you are permitted under the rules to testify about each of these elements of negligence. And, as we've mentioned a couple times, that's how you really add value. If we're getting down to the nitty-gritty, you as an expert can and should provide opinions about each element of a negligence action.
Think about it. We now have learned in this little webinar, of course, we got duty, breach, causation, and damages. Maybe you've been hired on causation, but start at the beginning. You're telling a story. You've been hired to tell a story, and if you just jump in and start, spewing your scientific knowledge about causation without setting it up as to how the duty in breach gets in there and what damages it caused, you might only need a few paragraphs to discuss each of those things, but don't miss the opportunity to touch on the big picture. You don't want to seem like you're just a microscope focused in on one issue. You want to have a command of the facts, and offering an opinion that builds upon itself, that encompasses all of the important aspects of a negligence case, makes you a lethal weapon. Or the defense, and you know, the same logic applies to defending the case, to the entire defense, pointing out how the standard of care was not breached, there was no causation, the damages are weak. Hit them all.
So let's talk in specific terms what you as an expert should be talking about when you talk about duty, standard of care, breach, causation, and damages. When it comes to standard of care, your job is to teach the jury what the applicable standard of care is. Juries are not given it's not the jury that decides how the doctor should have acted, how the product's manufacturer should have acted. You as the expert witness say, this is what the standard of care is, and this is what you should think about when you're finding whether it's negligent or not.
It invokes the authority that you're relying upon. I mean, if it's a building case and there are building codes, invoke the building code. That sets the standard of care. If it's a medical negligence case, invoke the textbooks and the treatises. This is how we teach our doctors to act. Invoke general practices in the field.
You can talk about your qualifications. You know, this is how I learned it. This is how every other doctor, how every other engineer, how every other mathematician, whatever, learned this in their training. Everybody knows this.
And standards of care evolve over time. Tell the story of how it came to be the standard of care. Say, look, we made these mistakes in the past, and we used to do it this way. For instance, police used to hit people in the head with nightsticks and billy clubs to get their attention during an arrest, but now we don't do that because we learned that it causes, these types of injuries, so we don't do that anymore. Tell the story, and you'll be very persuasive and very valuable.
And you'll be, you want to put it in terms, when we talk about why is it the standard, while a juror may not say, okay, I see why OSHA has these requirements, but if you can talk about why the requirements are in place, it makes it very concrete.
Okay, here's an added takeaway. I'm just thinking of it right now, Nathan. You ready for it?
Ready.
Jury nullification. If you do a good job as an expert explaining the standard of care and how it came to be the standard of care, you will minimize the risk that is present in every jury trial, that the jury's going to go back in the room and say, I don't give a rip what the standard of care is. I'm not going to find that doctor negligent because I didn't like the shirt that the plaintiff was wearing, or that they're going to go back and rewrite the standard of care and say, I don't think they should have to behave that way. I'm going to let them off the hook, or I'm going to sink their boat. So if you explain it and you're persuasive, you'll go a long way towards minimizing the risk of jury nullification.
All right, we'll move on. Breach, we talked about this quite a bit, but really as an expert, your job is to, we've mentioned that breach is fact-intensive. So as an expert, you want to point out, either in your expert witness report, your deposition, on the witness stand, these are the actions or omissions that I looked at when I decided this is totally contrary to the standards that we just talked about. Or if you're defending, say, look, these are the actions that are completely consistent with the applicable.
And this is where you add value by being specific, mastering the facts of the case, integrating very specific facts into your report, knowing that you've read the documents, you're going to point to specific facts where there will be no question, but that you have a complete mastery of everything that transpired that relates to breach of the standard of care.
Let's talk about causation. Now, we were talking about this before, and Craig's point, we were talking about how huge causation is. Causation is really the link between the first two elements, the duty and the breach, to your ultimate goal as a plaintiff, which is to recover money, or if you're a defendant, causation is where you can destroy the case. Destroy, saying, even if this other stuff is true, the first two elements, there's no link between those first two elements in any of the damage.
I mean, and if you're a rock star defense expert, if you are Genghis Khan of the defense expert world, this is where you live. You live in destroying causation in the plaintiff's case because it's an area that oftentimes is debatable. Why did something happen? Why did it happen? Well, That's why we hire experts to tell us.
And when you do that, the buzzwords, I think we talked about this in prior webinars, but, in all opinions, you're rendering them to a reasonable degree of certainty, scientific, medical, dental, whatever. But especially on causation, when I say, look, I am certain, I have a reasonable degree of certainty that A and B caused C.
Causation's where the armchair quarterbacking, the Monday morning quarterbacking comes into place. We use our retrospectroscope and we say, knowing what we know now, we wouldn't have done this because this caused this. This is really where the rubber meets the road on proving up the case. So making sure that you've given causation a good once-over as an expert. Even if you haven't been hired on causation, you're going to maximize value on the case. If you find a way to tell a lawyer, this is a risk out there for you because have you considered this? Obviously, you might not want to write that in your report the way that's discoverable and all, but, a phone call might be nice. But you can really add value.
All right, now moving on to damages, and this is a place where there's a lot of overlap from, if you're called to render an opinion about causation, you can get into damages. It's a good place to do that. You don't have to leave it, to the accountants. We typically think that we have separate experts to talk about to value a party's damages.
Or to explain pain and suffering. I mean, let's go back to the personal injury case where the part of the body is injured and you've had many cases like this before, and you know that when somebody has this occur to them, these are the kinds of things that have happened in other cases. You can relate your past experiences to the existing case and really drive the point home in relevant contemporary terms what the plaintiff might have been going through. Or if you're a defendant, you know that something is easily if you're defending in a particular event is easy to rebound from, you might offer opinions regarding that as well.
Now, you only want to do that if you know what you're talking about. Don't, that will destroy your credibility if you're talking about causation and then jump into, hey, I also know that this is super painful, or this causes all sorts of hungry. No basis for
that. That happened to me in high school,
right.
And that hurt a lot.
Probably obvious. Don't do that.
You should really only venture into that if you are, in fact, qualified to offer those opinions. But, pain, lost profits, damaged reputation, recovery time, those are all things that you probably know something about if you've been doing this for any length of time.
Now, one of the things we wanted to do here in the last 10 or 15 minutes that we have is talk about a specific case of ours, and we're going to look at a couple reports that were prepared by two experts that we retained. Now, it's a civil rights claim, which is more of a constitutional tort, but the concepts we've talked about today, you can see there. We've hired one expert to talk about the police procedures.
Right. We'll break it down to third grade level. We'll say negligence on the part of a police officer.
All right. Two experts. We'll look at one report from a police procedures expert and one report from a forensic pathologist who was giving his opinions on cause of death. These are good reports.
These are rock stars.
So if your reports look like these, you're doing a great job. The first one, you can see this is by an expert by the name of George Kirkham. This is our police procedures expert. He starts off with the standard. This is what I reviewed. But one of the first things he says here is that I've looked at the whole case and I see violations of well-established standards and procedures of the law enforcement profession on the part of defendants. And then he says, I'm going to explain. So he's already laying the foundation for these. There are standards in place for police officers, and I saw lots of violations.
And then he takes it to the next level and earns gold stars by saying, and my opinions remain true even if we give the benefit of the doubt to the officers involved.
Now, Dr. Kirkham, he also gets into breach here. Here's a little overlap. He combines the standards of care and the breach elements. A reasonably trained and competent law enforcement officer would have kept the individual ultimately was killed, kept him in view from a safe distance. This is what should have happened, but he did not do that. No exigent circumstances.
And then in talking about the standard of care, the decedent in this case suffocated, and he goes on to say, hey, why is this standard of care? Because for many years before this, we've known about this concept of sudden in custody death and a condition known as excited delirium. So he's saying this has been around for a long time. It's not a new concept that we're making up.
Well, and not only that, but he says here, a lot of law enforcement agencies are training officers on this sudden in custody death syndrome. And here he says, the officers behaved like they didn't even know about it, which, he says, here's the standard. Here they have not complied with them.
And then he drives the point home, dealing with the issue of damages, and basically says all of these actions would have foreseeable consequences of proving panic and intense resistance on the part of the individual under the influence of cocaine, which then caused the excited delirium and the death. So, good stuff.
You can see it sprinkled throughout here. He's pointing to studies for different standards. There are references to specific instances in the facts, how they breached. He said, here's a breach. Counties did not monitor the dead guy's condition after he stopped struggling. He says, here's the Highway Patrol that's saying this. So that's Dr. Kirkham. So he's combined all these things. Now, Dr. Kirkham, we asked him, can you get us our causation element? Can you give us an opinion on that? What did he tell us?
He did not waffle. He said, no, I cannot. I can tell you what they did wrong, but physically what caused his death is beyond my expertise, so that led us to Werner Universitas Spitz.
Dr. Spitz is the forensic pathologist, like Dr. Kirkham, started off with the standard language. Now, Dr. Spitz, Craig talked about getting into the causation or the, some of the foundational things, the duties and things. Dr. Spitz goes through a list of the facts, and he dives right into causation, which is what we hired him to do. The death, this is how it's asserted that the decedent died by excited delirium associated with cocaine and methamphetamine. I disagree. Very clear, he's given his opinion on causation.
And then he proceeds for several pages to explain to us why, but then he adds some value. He does give us the true cause, and then he gives us this little added nugget.
This was fantastic.
No additional charge.
No, that's right. And we as the plaintiff lawyers were particularly pleased when we saw this.
Explain what somebody goes through when this happens to them.
He's talking about asphyxial death where somebody suffocates. He says those people on our plane, our decedent, experience severe conscious pain and suffering and the fear of impending doom during the restraint while he was unable to breathe. Autopsy revealed no findings to suggest anything but normal life expectancy.
Damages. Did we ask him to opine on damages?
Absolutely not.
But did he?
He did.
And are we glad?
Absolutely. This is absolutely persuasive, and not only that, but he's qualified to talk about it. As a physician, he can talk, he's familiar with how people describe that sensation of suffocating, and it's totally credible.
And he's given the big picture. Now he's an expert that can take us from point A to point B, not just somebody that's hired to talk about something in the middle.
All right.
We got about 7 minutes left. Time for a few more questions. What do we got? How about legal negligence, misbehavior by an attorney? Well, attorneys don't misbehave, never make mistakes. In a legal negligence case, the rules are absolutely the same. There are experts that would testify as to what the standard of care, as to what lawyers should or shouldn't do under the same or similar circumstances, and whether or not a lawyer behaved appropriately.
And really, that's the convenient thing about these negligence actions. If you're familiar with the four elements we talked about and can speak intelligently about them, they apply to so many of the different subsets of negligence actions.
We've got another question from, let's see here. Can you find that, Nathan? We had another question from about banking, for instance, of the appropriateness of behavior, whether or not banks, for instance, should make risky loans which affect the value of the banks for the shareholders. That's an excellent, as far as the standard of care and breach, those are the kinds of things that experts are going to be able to talk to juries about. Juries don't have any idea about what the standard of care is, and that's where we really drive the point home that experts have to apply the standard of care to the facts of the individual cases in such a way that it really explains to the jury something that they know absolutely nothing about.
Well, and just because, this question is, there may not be any regulations that specifically deal with the percentage of loans that should be made in construction, that should be construction loans, but you aren't limited to just looking at regulations to establish negligence. You can look at industry standards. What are other, how great a percentage of investments are banks, or how much money are other banks loaning on construction loans, things like that.
And, that's where you can also tie in duty, because for those experts that are familiar with the concept of fiduciary duty, there's a duty, and then there's fiduciary duties, which are the duties to use the utmost care and good faith and fair dealing, where there's a relationship of confidence or trust involved. So those kinds of duties and breaching those duties, the breach of the duty is the negligence. It's that you've got this duty to be fair and to be forthright and honest with your principal that you're working for, and you just flat out don't do that. That completes the negligent act itself.
But you are not limited to something that's published by a governmental agency.
Oh no, not at all. Not at all.
You can look to all sorts of sources
now,
for your.
And just by way of explanation, where one violates a published regulation or law, and the violation of that results in harm, that's a special kind of negligence called negligence per se. That's where it is negligent because it is prohibited by a governmental regulation. And for instance, if you get a ticket for speeding and your speeding causes a collision, that's negligence per se, and merely proving that they were speeding and also proving the damages completes the chain of negligence. So another nugget, little takeaway, negligence per se.
And then we have one more question from Stephen Schmidt, who's a neuropsychologist. He said his testimony is often limited when he's asked about causation, whether an automobile accident caused some kind of brain damage. He said that because he's not an accident reconstructionist, he's not allowed to testify about that. And his typical response is to talk about, how quickly or the time of onset of the injury. Now, I think, another way you could deal with that is you may not be able to talk about how the accident itself happened, but there may be evidence of, how the person, their body moved, what they hit inside of the car, whether they landed on their head outside of the car.
Yeah, maybe there's a doorpost that's deformed, and we assume that, the government crash test says that a head has to hit it with so many foot-pounds of energy, and if we assume that the head hit the doorpost with this foot-pounds of energy, then it would deliver this to the brain, and that normally in scientific studies causes these kinds of problems.
Well, and that's what you can say is, look, the mechanism of the injury here is consistent with the ultimate brain damage that this person suffered. You don't have to get into whose car hit who, when, and where. But you can certainly look to the fact. There are facts that you can grab a hold of and use to support your opinion.
Little Ozark's wisdom would be we can set the table in such a way that they would have no choice but to eat the meal. You might not have to tell them to eat it. You just do it in such a way that it's going to happen.
All right, let's wrap up. The things there's one thing we obviously want you to take away, and that's first, you have a chance to add value to make more money as an expert witness, to be a better expert witness by rendering opinions on all the elements that you are qualified to opine about. Even if you aren't specifically asked to do that, you're going to be very valuable as an expert, like Dr. Spitz was to us.
Sure. But listen, and the next point is, charge for it if you can, but don't be afraid to give it away. Within the industry of expert testimony, if you give back, if you give more, it's going to come back to you tenfold. It's just a tried and true rule. Your reputation will grow, your demand will grow. Think of poor Dr. Spitz, sitting up there in Michigan, and here we are singing his praises just because he wrote 3 sentences that he never probably even gave much thought to at the time that he was writing it.
Well, and think about the effect, think about Dr. Kirkham. That's who I'm really impressed with, was that he said, look, I can't do this. You've got to find somebody else to do it. If he would have tried to talk about causation, he would have been murdered on cross-examination, at deposition, or trial, and we would not have hired him again. But because he said, look, you need to find somebody else who can do this for you, that's great value to us. So I think the big thing to take away from today is, if you're familiar with the elements of negligence, duty, breach, causation, damages, and can talk about standards of care and give opinions on all those things, your value as an expert witness is going to go up, and you'll be very successful.
Well, if anybody has any questions, you can message us privately at info@bolivarlaw.com. That's BOLIVARLAW.com, and just put in there attention Craig or Nathan, and that'll get routed to us. And with that, we'll turn it back over to you, Matt.
Thanks, everybody.
Great. Well, thank you guys so much. I thought that presentation was very good, and I hope that the experts who took an hour out of their very busy schedules to join us this afternoon have similar thoughts. Just a couple things to wrap up here. We will be sending out a link to the archived recording of this webinar, well, tomorrow morning being Monday morning, because tomorrow is Saturday. The archived recording will also be posted in the Knowledge Center of TASA's website. That would be tasanet.com/knowledgecenter.aspx. If you have any follow-up questions or comments, please email me at mhyde@tasanet.com. We do encourage both questions and comments. The comments help us to produce better programs. So please feel free to let us know what you think, and let us know how you think these can be improved. We're going to work on another expert webinar here. We're not sure of the timing, but we will continue providing these on a pretty regular basis. So please watch your inbox for invitations to future webinars. And we do have the archived recordings of past webinars in our Knowledge Center and available for download. I will send a link to those along with Craig and Nathan's email address, info@bolivarlaw.com, out in an email on Monday morning. So please, if you haven't checked out the archived recordings of the webinars that we've held previously in 2010, I do encourage you to take a look at those. Other than that, I thank you, Craig and Nathan. I thank you again for excellent presentation. And I'm going to keep the meeting open here for a couple more minutes, and then I'm going to shut it down. Everyone, please enjoy a nice weekend. Thank you.